My name is Joe Kukla. I'm an attorney. Our office, we have a small firm that is based in Edina. And we have been doing guardianships from that office for over 40 years. And my connection to this is that my youngest brother has developmental disabilities. And so when he turned 18, my parents had to go through this process, had to go through guardianship, had to set up their estate plan. And during that time, I was in law school, so I got to learn a lot about it. Didn't really know what the concept was prior to that. So I was very, I guess, inquisitive of the attorney that helped them. And his name was Bob Gunderson, and that's where the Gunderson in our firm name comes from. But he did this for years, was kind of the go-to guy in the metro area for guardianships, for trust planning, and sort of established that his practice and that firm was a main source or resource for people who had children with disabilities. And so he did a lot of work related to Social Security, SSI, SSDI, RSEI, a lot of work related to medical assistance, waivered services. So for me, being a sibling of a person who is going to be under guardianship for his lifetime and who is going to be on government assistance, I sort of took it upon myself to become more interested, more involved, and understand what all of that was. And the more I learned, the more I realized like how, valuable of a practice this was. It's not just estate planning. It's not just sort of general law. This is really focused on all aspects of special needs planning. And so I kept sort of a relationship with Bob Gunderson and with this firm. And when I became capable enough, after a few years of practicing, they asked me to come and join them. And that was 10 years ago. I've been there ever since. I'm now the managing partner of the firm. And Bob's daughter, Anna, is a current partner of mine. So this is something that we really focus on. It's about 70 to 80% of our work. And so besides just guardianship, we do all of this stuff. But tonight I'm doing a guardianship presentation, and this is primarily focused from the perspective of a parent who has a child who's turning 18, who needs to know what the guardianship process is, who needs to know why guardianship is necessary or what the considerations are when you're making a decision about whether to pursue guardianship or not. But a lot of this will apply to people who are older as well. People with autism, sometimes you may prefer to try and support the person independently for a few years. It may not be automatic at age 18 that guardianship is necessary. You determine at a later time that it might be. But if independence works, that's sort of our goal. That's guardianship is there if it's needed, but we also want to look at the less restrictive alternatives and determine whether guardianship is absolutely necessary to protect the person who might be vulnerable to exploitation if they are left to their own independence as an adult. Let's see if I can manage to, there we go. And so hopefully on the video, you guys can see the screen. And for you in the audience, if you want to stop me and ask questions, that's fine too. I'll pause and repeat those for the camera. But just a little bit of background on where we start with guardianship in general. of course, incapacity is the key term here. Everybody, when they are growing up, reach the age of majority at age 18, right? And so everybody at 18 becomes an independent adult in the eyes of the law, regardless of your status, regardless of your capacity issues at that point. You are legally an adult at age 18. The reason for considering guardianship is if you have a person who at age 18 may not be ready for the responsibility of making independent choices, because you have those rights, you know, that the individual rights that we all have, the constitutional rights, those are granted upon us at 18. But it does also mean that you have to take responsibility for your own decisions and your own actions. And the concept of guardianship is meant to protect somebody who, if they were responsible for their own decisions, they could be vulnerable and taken advantage of. So just to touch on this briefly, because I know the terms kind of get tossed around together a lot, guardianship versus conservatorship. Guardianship is taking care of the person. It's making sure that all of their personal needs are being met. It's taking care of their housing, where are they going to live, taking care of medical decisions, taking care of their benefits, which I'll get into in a couple of slides here in more detail. But conservatorship is taking care of the estate, which means taking care of the money. And so it's less applicable to somebody who's turning 18, because most people who turn 18 don't have any money. So we rarely have a petition for somebody at age 18 for both guardianship and conservatorship. But conservatorship comes into play a little bit more if you've got somebody who's older, who becomes incapacitated later in life or diminishes in capacity, who has already accumulated personal assets. And they haven't set up like a power of attorney or a trust or anything where they have directions for somebody else to manage their personal estate if they lose the capacity to do so themselves. And so you see, conservatorship is a lot more common when we're talking about like an elderly person or a person who's been in an accident and suffered a brain injury, where now we have a bunch of bank accounts, maybe a house, vehicles that have to be taken care of by somebody because that person no longer has the capacity to do so. So, like I said, we're talking about this more from the perspective of somebody being appointed as guardian for a person who's 18 years old. So I'm not going to spend time in these slides on conservatorship, except to the extent necessary. So as I sort of briefly touched on there, the powers of the guardian are sort of the critical litmus test for whether guardianship is going to be necessary or not. So when people contact me and want to discuss guardianship for their child, the consultation that we go through is a discussion about these powers. And what we're doing is we're analyzing whether the person can manage to take care of these things or make these decisions on their own, or whether they need help with that. Now, there is some consideration here for the fact that if we're petitioning for guardianship of an 18-year-old, you know, when you look at these powers, you think about, well, how many 18-year-olds can make these decisions on their own anyway? You know, it's a question about whether anybody is fully prepared for adulthood at that age. You know, is a legitimate question. But as I've been saying, the real question about guardianship would be if the person was responsible for their own decisions, would they be vulnerable at risk of exploitation because of their diagnosis? So this is more about protecting a person after they become 18 years old from being taken advantage of. So these powers, as we look at them and analyze them, in the petition for guardianship, we can either petition for all of the powers as they're listed here, and in the statute, these are spelled out in much more detail. This is just sort of a headline caption of them. But we also have the option to narrow down this list and petition for specific powers. In that case, we call that a limited guardianship. And this is done with the intent, again, of trying to promote as much independence as possible. And so when we look at the powers of the guardianship, the first one, establish a place of abode. This is simply put, where is the person going to live? And this could be, if the parents are the guardians, this could be at the parent's home. It could also mean establishing them in their own apartment or condo. It could also mean establishing them in like a group home, semi-assisted living, any residence where they're going to live. The guardian has the authority to set that up for them, make sure that they're established in a safe, comfortable place. Along with that is the guardian is responsible for providing for the care, comfort, and maintenance needs of the person who's subject to guardianship. So basically, wherever they live, the guardian is responsible for making sure that they have everything that they need to be safe and protected and comfortable in that residence. And so this is simply just supervision, making sure that that they have everything that they need. And so this is sort of an ongoing power. It's not one that we usually limit because it's very general. If you're appointed as a guardian, you're probably going to do this naturally anyway. Just the idea of making sure the person is comfortable. The third one is one that we look at and do often limit or reserve for the person who is subject to guardianship, and that's taking care of personal property. And so somebody who is a little bit more higher functioning, who has some independent skills and social skills, and capability of appreciating what they own, and appreciates like the value of property. This can be anything from video games to furniture to clothing to even like vehicles, anything that they consider their own stuff. And so the idea here of making this a power that is subject to guardianship is in the case that they would be vulnerable or be exploited for that property. Somebody has like a brand new PlayStation 5 and their friend comes over and wants to play with it, and then the friend says, can I bring that home with me? And if your son or daughter says, sure, there you go. It's sort of an example of they don't really appreciate the value of the property. And even though they're over the age of 18, legally they could do that. Of course, any one of us could give away whatever we have. But the idea is giving the guardian the authority to intervene and make sure that that property is protected. The fourth one is probably the most critical power of guardianship, and that's give consent to medical or other professional care. And this is a power that is necessary if doctors or medical staff determine based on the person's diagnosis that they lack the ability to give consent. Meaning any one of us, we're all subject to HIPAA, the privacy rights. But if we are at the doctor, we can consent. You can say, you know, my spouse is in the waiting room. I'd like her to come in here so that she can see the results of my test. And we can make this decision together, you know, about my medical care. Well, if the doctors determine that the person lacks the capacity to give meaningful consent to that, the doctors are not allowed to speak to anybody else. That includes parents after age 18. And so this is often, the guardianship petition is often going to be instigated by like your primary care doctor, your pediatrician, who says, you're going to need guardianship after your child turns 18, otherwise I have to stop talking to you. So that's the big one. And a lot of times when we do a limited guardianship, it will be specific to that power. Approve or withhold approval of any contracts. This is not a power that gives the guardian the right to manage money. What it does is it says that a person who is under guardianship has the right to enter into a contract still. They can sign up for a phone or, you know, some kind of a service through an app or things like that, and it would be perfectly legal. But the guardian has the right to terminate that contract if they feel like their child was taken advantage of and didn't understand the terms. We have had that come up several times over the years. We've had like credit cards are a big one for that, because you can go to the mall and there will be a kiosk and you can sign up for a credit card if you know your social security number. We've had, and then of course the online shopping leads to a lot of trouble with that. I always remember there was one young man who, he was about 28 or 29 years old, had Down syndrome, lived over by Mankato, and he had gotten a hold of a credit card somehow that his parents weren't aware of, and he had a girlfriend, and he started buying her jewelry online and ran up like $20,000 tab on his credit card. Luckily, his parents had guardianship and were able to work with probably Visa to make sure that that was all those purchases were canceled and reversed and all of that. So it is a valuable power, but don't mistake it for giving the guardian the authority to manage money. As I mentioned before, with conservatorship, that's a distinct act. That's a distinct petition that people have to file. So for those of you that think guardianship gives you the authority to manage a bank account or any other personal assets, it does not. Sure, go ahead.
Is there a limit? So for example, I'm my sister's guardian, and we handle like her paychecks and things like that. She has a bank account, but is there a dollar limit? Like, I think I just have guardianship, but maybe it sounds like I would have a conservatorship at that if I'm handling the checkbook and things for her.
Right. So the question was whether there is a dollar limit for managing money on another person's behalf, and no, it's the authority to manage any assets whatsoever. You have to have either the consent of the individual to do so, which in a lot of cases, when you have a younger person, like a mom or a dad can walk into the bank and say, you know, I want a checking account established for my son. He's turning 18, we want to do that, and I want to be joint on that checking account. Well, the bank will let you get away with that in a lot of cases. And so then you're fine, but that has nothing to do with the guardianship. Technically speaking, according to the law, you should have conservatorship to be able to do that. But if they accept the consent of the individual, then that's fine. So we actually try to take advantage of that a lot of times to make it easier instead of having to go through a conservatorship process. But there is also, when we get here to power number 7, power number 8, The power to apply for government assistance benefits includes the power to apply for Social Security, it's SSI. When a person qualifies for SSI, they are typically set up with what's called a representative payee. And a representative payee is essentially granted power of attorney by the Social Security Administration. And so you set up a bank account as the guardian, you're granted authority to manage that account by the Social Security Administration. And so if there are additional assets that the person has, we sort of advise the guardian to funnel those assets into that representative payee account, because as far as the bank is concerned, they have the legal authority to manage whatever assets are in that account. They don't distinguish between SSI distributions and, say, if they have wages from working 10 hours a week at the Hy-Vee. You know, those same assets can go into the same account, and then the representative payee can manage that account legally on behalf of the person who is under guardianship.
And is that still under the umbrella of guardianship, what you just described?
It is,
Okay.
yeah. Question was, is that still under the umbrella of guardianship? And yes, it is, because the initial authority to register for SSI and register the account with Social Security is a function of the guardianship. This is also a power of conservatorship as well. It's a crossover for people that are, just seeking conservatorship. But this is sort of a limited ability to manage money on the person's behalf, but it's not granted by the guardianship statute itself. Just being appointed the guardian does not give you the authority to manage a bank account. This power is basically granted by Social Security to allow you to manage the account on the person's behalf. Establishing an ABLE account is another component of that. The guardianship statute says that you can establish an ABLE account. For those of you who don't know, ABLE is an acronym for Achieving a Better Life Experience. This was designed, it's relatively new, it's only from 2014 or 15. And it's a congressional act that created an account that is designed to be managed by the individual themselves. And so the idea here is that there are a lot of people who are capable of working, but still need the services that are provided through the county. The services that are provided through the county have an asset limit attached to them. Your eligibility is related to your eligibility for medical assistance. And so in some cases, that can be a $3,000 asset limit. If the person is employed, that could be bumped up to a $20,000 asset limit, but you still have an asset limit that has to be maintained in order to stay eligible. So the concept of ABLE was, let's not make a person choose between working and earning wages and receiving services through the county that they may need. I mean, this could be ride services, this could be PCA services, these things that make it possible for them to work and potentially live independently. So what our legislature did in 2020 was add this power to the guardianship to say that a guardian can establish an ABLE account for an individual. Realistically, it's sort of for a small, niche of people, because the legal requirement is that the person who is the owner of the account manage those assets themselves. Again, the guardian doesn't have any inherent authority to manage money on the person's behalf. So we've had some sort of resistance, there's some sort of getting used to it period with banks who host those accounts, saying that the person needs a power of attorney if the guardian is going to manage the account. Well, of course, if they're under guardianship, they lack the capacity to execute a power of attorney, because the guardianship order itself carries a finding of incapacity. And so there's a little bit of difficulty with that. That's something that is best addressed on an individual basis as to whether it's appropriate or not.
And is that where the special needs trust then come in?
Correct. Yeah, so the question is that where the special needs trust comes in? And so when ABLE was rolled out, it was sort of talked about as an alternative or a replacement to the special needs trust. And it's not entirely that, because as I said, first, ABLE is supposed to be managed by the individual themselves, but there's also a few limits to it. You have to have been declared disabled before age 26. So that doesn't always apply to somebody who loses capacity later in life. But you are also limited to contributions totaling $17,000 per year. So if you have something like a windfall of, you know, you may have inherited $50,000 from an uncle or something, that money can't go into an ABLE account because of the contribution limit. So then the special needs trust is the vehicle for that, or the instrument for that, and it's managed by somebody else. The money is then not countable towards their asset limits, just as ABLE is. But yeah, the concept is the same. It's just a matter of, can the person manage the money themselves, and is it a small enough sum that it's going to stay under those contribution limits? Okay, and then just the last one they added in 2020 as well. You can stand in basically as a proxy for a person who is the subject of a civil case or even a criminal case, if they lack the capacity to understand what's going on. But very importantly, no guardian in any capacity ever assumes responsibility for the actions of the person subject to guardianship. So if that person is arrested for any reason, it's not the liability of the guardian. If that person has a claim against them for a lawsuit for money or anything like that, the guardian is not equally responsible, is not responsible in any way for those financial damages, but they can appear in court just to make sure that the person who is the subject of that action understands everything that's going on. Okay.
Can I ask one question?
Sure.
So we talked about finances. What about employment? So can you help make those decisions of having a job or not having a job, or specific ones?
Well, it's an interesting question. The question is, can the guardian help make decisions about employment as far as should they have a job, should they not have a job? The guardian can certainly assist the person in getting a job. Whether they work or not is one of those things that is emphasized as a power or a decision that is supposed to be reserved for the person who is subject to guardianship. One of the slides I have here later is referred to by the legislature as the Bill of Rights for a person subject to guardianship or conservatorship. And so there's an acknowledgement from the state legislature that even though we are restricting this person's individual rights, there are still a lot of things that we have reserved that they should be able to do themselves. And so it sort of goes along with, you're assisting this person, but at the same time, you're trying to preserve as much independence for them as possible. So yeah, the guardian certainly plays a role in the employment process, but it's also something that you can sort of step back and let them handle themselves as well. So if you have decided that guardianship is necessary, the procedure to establish guardianship requires going to court and having the judge declare that guardianship is necessary. Because again, we are we are petitioning to say that this person should not have the individual rights that everybody is automatically granted at age 18 because they would be vulnerable. Well, so you have a responsibility to prove to the court that number one, guardianship is necessary, and then number two, that the petitioner or petitioners are the most suitable people to be the guardians. And so we start with the consultation for that. That's exactly what I was talking about. We review the powers of the guardianship. We review the circumstances, determine whether this is absolutely necessary. If we decide to go forward with it, first thing is the petition saying this person needs a guardian because of this diagnosis, and that's where within the petition we have to state what the disability is, why the guardianship is necessary, and then we propose who the guardians are, and say that this person or these people are the most suitable ones to make these decisions. The petition is typically supported by a physician statement. Technically speaking, the physician statement is hearsay because they're not going to show up in court to testify to the truth of what they're saying. But general practice over the years with all of the different counties basically allows the physician statement to come in because they want some kind of confirmation of what the diagnosis is. Otherwise, we could say whatever we want in the petition. In order for the court to make an independent determination of the need for guardianship, or at least evaluate for themselves rather than like what the parents are saying is a need for guardianship, they have what's called a court visitor. And in most counties, the court visitor is going to be a social worker that is employed by the district court. And their job is to interview the person who is going to be the subject to the guardianship. And they read them the petition. They ask, is this, do you understand this? Are you comfortable with your, parents presumably being the guardians? And then they file a report with the court as to what those responses were. Now, if you have a person who is profoundly disabled and is unable to comprehend, is unable to respond to those questions, that's what they're going to report. Again, this is a social worker. They are experienced in dealing with people with a wide range of disabilities. And so they're not going to badger the person like, this is important, you've got to understand this. They're simply going to ask the questions they're supposed to ask and report their responses to the court for the judge to take into consideration. A lot of times this is just a rubber stamp on the need for guardianship. There is a court-appointed attorney in most counties. The court-appointed attorney has a role for the person subject to guardianship because it's a due process concern. If the person does not want guardianship, they will be able to tell their attorney, and the attorney will argue for them. Again, most of the time, the court-appointed attorney is basically just along for the ride because the need for the guardianship is unquestioned. The parents or another family member is petitioning for the guardianship, so we're not terribly concerned. But they do play a role in cases where guardianship is less certain, or if we've got a dispute over who should be the guardian, then they become more active in that process. There is a criminal background check that has to be applied to, or that has to, that the people petitioning for guardianship have to go through. So even parents have to submit the consent to a background study. But there is an exception in the statute that says that if the judge approves, we don't have to subject the parents to the background study. But if you are a brother or sister or cousin or somebody else, or even a grandparent who's petitioning for guardianship, you should be aware that you're going to be subject to a criminal background check, and you're going to be required to resubmit your consent every few years. Every county has a different timeline for that. But it's usually 3 to 5 years you have to go through that process again. There is an educational video put out by the judicial branch website, and that can be found on mncourts.gov. It's also easy if you just Google it, Minnesota Guardianship video. It's about a 25-minute video that just sort of educates you on the role of guardian and what the responsibilities are going forward. The court hearing itself is a matter of proving up the petition. And so in a lot of places, we will simply show up at court and the judge will review the court file and say, everything looks to be in order. Court-appointed attorney, do you have any objection? Court-appointed attorney says, no, no objection. And then that's it. That's the end of the hearing. Very anticlimactic for, for everything that we're going through. But if the process is done right, if the documents are filed correctly, if all of the information is there, that's the goal, that the hearing is nothing more than a formality and everything is really easy, but it's still required. The nice thing is that following the pandemic, all of the district courts in the state of Minnesota shifted to Zoom for their court hearings. And they decided, even after the pandemic restrictions ended, that this was a pretty efficient way to do a lot of these types of cases. And so now all guardianship cases are done via Zoom, which helps, and which is part of you know, me being here in Rochester doing a presentation, even though our office is in Edina. Typically, I would refer people who contacted me for guardianship from outstate areas or basically further than like 25 or 30 miles away from our office, that you should get somebody who's more local so that you don't have to pay additional costs for us to come out and represent you, you know, after an hour-and-a-half drive or something. But now the guardianship hearings are all done on Zoom. So I attend them from my desk, my office. And so we can represent anybody throughout the state of Minnesota. And so now we've been appearing in courts everywhere, in Duluth, Redwood Falls, you know, Otter Tail County, Detroit Lakes, even down here in Rochester and Austin and places like that. In fact, I was just in court in Olmsted County earlier this week, even though I was sitting at my desk in Edina. So that's just to say that that the restrictions on where you're at have been lifted at this point. So and for the people themselves, it's real easy to attend the guardianship hearing from home. So it makes the process a lot easier. Something I always am asked about, of course, is the cost. If you talk to a case manager or a social worker at the county, sometimes they will say guardianship is free. Guardianship is not free. Attorneys who represent petitioners in a guardianship can be compensated by the county. And that's because of the concept of informa pauperis that's in state law. It means this action is required for the individual, but the individual does not have the money to pay for it. Doesn't matter about the parents or the petitioners or anybody, what their financial status is. It's the 18-year-old or the person subject to guardianship, what their personal assets are and what their ability to pay is. And so a lot of times you will have the county contributing to the expenses of the guardianship. And that means the court filing fees, that means the fee for the court visitor, that means the fee for the background study, that means the fee for the court appointed attorney. But in a lot of cases, they do not pay the fees of the petitioner's attorney. And so we ourselves at our firm, we employ or apply a hybrid model where we do apply for the informa pauperis. We get the relief that's worth about $1,800 to $2,000 in additional court costs. but then we charge a separate fixed rate fee for the petitioners to go through this entire process. We try to keep it reasonable, so. But then going forward, what you should know, if you are appointed guardian, is that there is an annual filing requirement. Essentially what's happening here is the person who is subject to guardianship is now an independent adult, but now they're under the supervision and jurisdiction of the court, because we've told the court, here's a person who is in your community who needs protection. And so the court is responsible for that protection. The first step is appointing the appropriate guardians for that person. And it may be the parents, but the parents have to realize they are now officers of the court. They are not just parents. And so for the court to maintain its supervision, you have to file an annual report, which is referred to as a personal well-being report. It's about a 3 or 4 page document that just goes through questions. How many times have you seen this person during the past year, right? Has anything changed? What, have they improved in any way? Have they diminished in any way? Just to make sure that the court is keeping an eye on things and understanding how things are going. One of the other things they added in 2020, the legislature added, is that if you are petitioning for guardianship of a person who is under the age of 30, there is a required term limit on that now. And that maximum term is 72 months or 6 years. What that means is that after 6 years are up, we have to essentially renew the guardianship. How that's going to happen is going to be up to the individual counties, and we don't quite know yet because this law was only passed in 2020. We're only at year 3. We haven't really hit any of those renewals yet, and a lot of the district courts haven't quite figured out, is there going to be another hearing required, or can we just simply file a document saying like, yep, guardianship is still necessary, let's renew it and move on. But just to be aware that if you are appointed guardian of an 18-year-old, it's going to be for a limited term of 72 months, and you're going to have to reevaluate and renew at the end of that. The purpose, again, is promoting independence. As I was saying before, a lot of 18-year-olds are not ready for independence, regardless of a diagnosis or anything. So this acknowledges that a person with autism or Down syndrome or any other disability at age 18, they may not be quite ready for the real world, but maybe at age 24 they are. And so we want to reevaluate whether guardianship is necessary or not.
I think that's a good point too, because like the educational system, they are in the public schools till 21, and 18 to 21 is where they have a lot of those life skills and independence skills.
Absolutely.
So I like that a lot.
Yeah, absolutely. Yeah, the comment was that a lot of people learn life skills, through those secondary programs, 18 to 21, the transition programs. And you're right, that's absolutely the point, is maybe they are a few years behind, but they catch up in the next few years, and guardianship is appropriate. To that point, guardianship is always subject to termination. The person who is subject to guardianship always has the right to file a petition saying, I no longer need guardianship. Now, the burden of proof would be on them. They would have to come up with supporting medical evidence, supporting arguments, or the parents or whoever the guardians are can simply agree, and we can terminate the guardianship. And when we have that, it's nice. It's sort of like a graduation. It's everybody is in agreement that this person can be independent and responsible for their own decisions, and guardianship is terminated at that point. So I'm going to try and roll through quickly here because I know we're running out of time. But some of the special considerations in the court process, we do have to address the person's right to vote. Because at 18, that's a right that you automatically get. And so the attitude from the legislature and from the courts is that we'd like to retain the person's right to vote unless there is a finding of it's absolutely not appropriate. What we don't want is a guardian using their authority to influence the person. The guardian cannot go into the voting booth. The guardian cannot fill out the voting ballot or anything like that. There is assistance that's available at polling places for people who need accommodation. But if the person has absolutely no concept and they would be vulnerable to somebody sort of taking advantage of that, then we do restrict or remove the right to vote. But primarily what I look at, the way I look at it is, okay, maybe this person doesn't have the capacity or the wherewithal to vote at age 18 or 21 or 25. But if they may have that ability at age 30 or age 40, let's not take away the right to vote, because you'd have to go back to court to reinstate it. And just having the right to vote, as most of us know, does not require you to vote. So we sort of, I guess the attitude of the judges, at least in my experience, is let's not remove that right unless it's absolutely never going to be a possibility. The consent or the ability of the guardian to make medical decisions is limited when we're talking about experimental or extraordinary procedures. And so if there is anything that's extremely sensitive as far as a medical issue is concerned, the guardian usually has to go back to court to get approval to make a decision. And that procedure requires that they have the support of at least 2 different doctors who agree on the decision and agree that this is in the person's best interest. Where this comes up a lot is sterilization, things related to really permanent personal decisions. And so we say, look, the guardian shouldn't just be able to make that independently. They need to really have like everybody else involved and determine whether this is appropriate. As I mentioned before, there is a Bill of Rights for persons subject to guardianship or conservatorship. I do have a couple of slides for that, and so that'll be in the handout that's available. It'll also be available if anybody wants to look at it, just online. If you go to the statute here, plug that into Google, Minnesota Statutes 524.5-120. That lists what the legislature has determined should still be the independent rights of a person subject to guardianship. What you do in the case of divorced parents is always an interesting topic, because guardianship falls under the probate court. It's not a family court matter. And so what the probate court says, and this has been confirmed by Minnesota Supreme Court decisions, is that guardianship cases cannot decide custody, or at least will not alter the terms of a custody agreement that's determined by the family court. And so basically the guardianship procedure needs to include both parents, if we're talking about a child here, needs to include both parents, and if they are divorced, they have to be able to work together and make decisions, because it's not like when Jimmy is with mom gets to be the guardian and make all decisions, and then when Jimmy is with dad is the guardian and makes all decisions. No, they have to work together on all medical decisions, on decisions about where he's going to live, on dealing with the benefits. All of those things have to be unanimous decisions. And so the probate court, again, is not going to adjudicate that and determine which guardian is more suitable between the two in most cases. So if you have 2 parents that cannot work together, there is too much tension, disagreement there, Unfortunately, usually what the court is going to do is say, okay, you're both out then, because we have to act in the best interest of the person here. And that means we're going to get a third party. We're going to get a neutral person to be their guardian. And so it is always in the best interest of the parents, if they are divorced, to figure out if they can get along, at least for the sake of their child. So those are the cases that usually lead to litigation and guardianship that we try to avoid. And then that's where the court-appointed attorney comes in, everything. So, as I mentioned, the Bill of Rights for a person subject to guardianship. And I always bring this up just to drive it home that there are still rights, because we're talking about all the things that we are taking away from an individual. Remember that they still have things that they can take care of themselves, okay? And I'm not going to go through each one of those in the respect of time. But one I do want to point out that comes up quite often is number 11. A person subject to guardianship does still have the legal right to get married. They do not need their guardian's permission to do that. They do have the legal right to have children. They don't need the guardian's approval to do that. This is a touchy subject, because I get calls from parents all the time who are upset with the person that their 28-year-old daughter is dating or is about to marry. And there's a fine line that we have to walk there between their individual right and the right of the guardian to protect them where they are going to be vulnerable and possibly exploited. So it's a scenario that we really have to analyze, but you have to keep in mind, as I remind parents all the time, when they call and say, I don't like this guy that my daughter is dating, I don't want him to get married. I said, that's a tale as old as time. You're not the first person to disagree with the guy that the daughter is dating. So, I guess that means we got to be close to the end of the presentation.
Shall we plug in, or are you good?
No, I think we'll be good because you want me to wrap up here anyway, so.
Sometimes your laptop dies 2 seconds after it says that, other
That's
times
true.
it's 15 minutes, so I don't know.
Let's see what it says. Oh yeah, 8 minutes.
Okay, so,
Well, let's see.
all right, yeah, because we just plug into what we've got right here,
Oh, okay.
and that should reach, so.
All right. Let's just pause for a second.
Charging sign up?
Yep, perfect. Thanks, Michelle.
Yeah, of course.
Okay, and then this last slide is important because it does follow the same theme that I've been expressing throughout here. In that we do not, when people contact us and say, I need to get guardianship for my son or daughter, we do not automatically just go, okay, let's start filling out a petition. We want to explore the alternatives to guardianship first. We want to determine if there are other modes of, or other methods of assistance that a person who has has a diagnosis, maybe is on the spectrum, or has some other incapacity issues, would they be able to be an independent adult if we just had some other assistance for them? And number one is that I've talked about is limited guardianship. That means choosing the specific powers of guardianship that are necessary, but also reserving other powers that the person may be capable of taking care of themselves. Again, the personal property power is one that comes up most often in that. It says the person can take care of their own stuff. We don't need a guardian to have legal authority to take care of their belongings for that. So that would be a limited guardianship. But in lieu of guardianship, the person can give their consent, as we were talking about a little bit before with the medical decisions. Every one of us that's over the age of 18 probably needs a healthcare directive. I shouldn't even say probably. We all need a healthcare directive. Because if you are in an accident, if you are unconscious, not able to communicate with the doctors, not even your spouse can see your medical records or make decisions for you. Doesn't matter how much screaming and yelling they do in the emergency room, the doctors are restricted by HIPAA from disclosing any information if you have not given your consent to do that. So how do we give consent in those situations? We have a form already signed and filled out that says, if I am not able to make my own decisions, my wife can do that, or my brother can do that, or my mother can do that. And so if that is something that a person who maybe is on the spectrum is capable of doing, this is a way of keeping your mother or father or family member involved in your medical decisions, but also still sort of learning how to make those decisions on your own. And it's basically a safety net. If you're unable to speak to the doctors or really comprehend what the doctors are telling you. So this is often something that a person who is a little bit higher functioning will encourage them. We will encourage them to try this first and try to utilize a healthcare directive, try and sort of establish things on your own. But if the doctor or any specialist that they go see says, no, this person lacks the capacity to give their consent, so I'm not going to accept their healthcare directive, then that's when we know for certain that guardianship is necessary. Just so you know, the healthcare directive is a two-part document. The first one is healthcare power of attorney, where you appoint your agent with the authority to make decisions. Part two is that living will, where we talk about if I am unconscious and there's no chance of recovery, then here's how I'd like to be treated. The next one on there is the financial power of attorney. This is also a way to assist somebody who is trying to be independent. If they give consent to another person to transact and manage assets on their behalf with a financial power of attorney, that can also serve as a safety net or a way to give somebody else the legal authority to provide assistance without having a court order or intervention in that. Supported decision-making is just a general concept that a lot of nonprofits, a lot of organizations will provide as a program. This is something that you can seek out on your own. This would be like a sort of like a PCA, but dedicated to helping the person decide things like where are they going to live, where are they going to work, what benefits do they need. It's really just sort of like a co-pilot, as you're going through life. And so these programs, if you seek them out, I know Volunteers of America is a good source for that, for finding supported decision-making options. But locally, there are all sorts of nonprofits that can help you with that. Technological assistance is the same idea. There may be ways that, like, using an iPad or something of that nature makes living life independently more easy. And so these are things that we just talk about when we're consulting about guardianship and determining whether it's absolutely appropriate. And so if none of these alternatives are applicable or sufficient, then that's when we know guardianship is necessary and appropriate. And so that gets me through the whole presentation. And so I think we'll wrap it up unless you guys want to ask one or two more questions.
How often do you have to fill out the healthcare directive?
Question is, how often do you have to fill out the healthcare directive? And the answer to that is once, unless you have changes to it. So usually what we do, and this is something too we do in general estate planning, like if just a husband and wife were to come see me about their estate plan, I'm gonna ask them, do you have a healthcare directive? If they do not, we include it as part of the estate plan. And then the instruction from there is, after you've signed it, it's been notarized, give a copy to your primary care doctor so that they put it into your My Chart or whatever, and it's preserved there so that, and then if you have to go see a specialist or anything, you want to provide it to them. But legally speaking, healthcare directive is effective until it's rescinded or revoked. And so we have, you know, in our client files, we have healthcare directives that go back to the early 80s, and those are still effective legally.
And do you recommend keeping the original and giving copies to the lawyer and the medical community?
Yes, I do. The question is, do you recommend keeping the original and giving copies to everybody else? Yes, that is usually what I recommend. But you should always keep the originals of all of your documents, give copies to everybody else. And this has become a lot easier. There were things prior to COVID that, you know, you were expected to provide originals for. Those requirements got relaxed quite a bit, and so like a photocopy of a healthcare directive is usually sufficient at this point. Yeah.
What age do you recommend starting the process of guardianship, when you're a mom or a dad, or?
Yeah, good question, because I get that a lot. The question is, at what age do you recommend starting the process? So from a strict legal perspective, mom and dad still have the legal authority to make all decisions for their child up until, you know, the 18th birthday actually occurs. So when you file a petition for a child who's 16 years old, the court is going to dismiss that and say there's no purpose for appointing a guardian here because the parents are the legal guardians by default already. But the courts do acknowledge that sometimes a gap in that authority could be detrimental. And so they don't make you wait to file until the 18th birthday. You can file as much as, I don't know, we've gotten away with like 6 months prior to the 18th birthday, and the court will appoint the guardians even if it's a couple of months early, knowing that they don't need that authority even for 2 more months or so. But the court process itself is, in most districts, going to take about 6 to 8 weeks to complete. And that's usually due to the fact that once we file the petition, the court calendar is like 6 weeks ahead of us. And so we'll have to wait for the hearing date, which will be out of ways. And so I usually recommend to people that if you get the process started about 3 months prior to the 18th birthday, you should feel pretty comfortable about getting a court hearing and being appointed by the time the person turns 18. Now, if you procrastinate a little bit and you go over that time, and you know your court hearing is until like 3 weeks after your child's 18th birthday, in most cases that's not a problem, because if you're dealing with the county, if you're dealing with a school, if you're dealing with a doctor, they're familiar with guardianship. And so if you can show them that we are going to be appointed guardians, we have a hearing coming up in 3 weeks, they're usually pretty accepting of that already. They're not going to give you a hard time in most cases. So, but if you're extending that to like a year, then they might start having concerns about their own liability and in letting you make decisions. So yeah, best to time that up as good as you can.
Well, thank you. It's been very informative.
Good. Thank you for coming. Thank you for your questions. Yeah, and thank you to everybody on the video. I hope you got a lot out of this too. So yeah, just be aware of what the process entails. Be prepared for it, and consider what the options are before committing to it. It's not an absolute. So just yeah, think about the process and good luck with that. So I guess that's where we'll end.